Good evening, everyone. Welcome to tonight's webinar. My name is Reddy. I'm the program director here at YEP, and I would like to welcome you to tonight's presentation. For those that may be joining us for the first time, YEP is a nonprofit, non-political, and non-religious organization whose mission is to inspire, educate, and empower the Ethiopian professional community to be able to make a positive impact in the world. We're driven by our vision to build a strong community that shares ideas, skills, and resources to enrich lives. Tonight's Intellectual Property Awareness Seminar is brought to you by our Personal Development Program. If you have any questions as the presentation progresses, please make sure you put them in the chat and we'll do our best to address them either throughout the presentation or at the end during Q&A. Really thankful to have two individuals here from the USPTO to give us insights and expertise around different sort of IP protection types. So we have Stephen Yanchuk and Salu Okabato, and I'll go ahead and bring up Stephen here on stage. Stephen, thanks for joining us. If you'd like to give us an introduction on the program, sort of the high level, and then we'll go ahead and jump into the presentation.
Sure. So thanks so much for having me today. I'm so glad to be here. The United States Patent and Trademark Office is, you want to bring up the slides? So we're a federal agency and we protect patents and trademarks, and you're going to find out a little bit more about what those are and also just how it fits into the larger, not only the nation and what the benefits of patents can do for you as an individual, trademarks and how they can protect what you build in terms of your reputation, but also how this whole system kind of came into existence and how they work together in order to be part of being an entrepreneur and an innovator and inventor. So today we're coming to you because of the United States Patent and Trademarks Office. Council for Inclusive Innovation stood up the Community Outreach Campaign, which is where we empower our primary patent examiners and other USPTO employees to go out into their communities, find audience members such as yourself, and create these opportunities for us to connect so that way we can share the importance of intellectual property. This is the start for many of you into your journey of what IP is and what it means for you as somebody that is engaging in business practices here in the United States. And so really we're starting off at the very high level. And if you have deeper questions, we're here at the USPTO, the Eastern Regional Outreach Office, and the Community Outreach Campaign in order to address those questions. So real quick, I'm just going to kind of give a brief overview of what IP is, who the USPTO is, and then about our initiative, and then I'll introduce Salu. And so, when we're thinking about intellectual property versus physical property, you might be sitting there thinking, well, of course you know what that means, right? Don't you? But when you break it down, you got to think like, why would you protect your intellectual property? It's that stuff that when you think about it in your mind, as soon as you communicate it, whether it's verbally or in writing or making a model and somebody else sees it, that they could then take that and go to somebody else. And without protections for you as the inventor and the person who originated that content, somebody could just take your idea and say that it was theirs. And so there's this whole system that was created to take this intellectual property and make it protectable. And there's reasons for doing that. Like if we start to think about why would we want to protect our individual intellectual property, it's the same reason that we want to protect our physical properties, right? If we didn't have deeds on houses or on our cars or this social construct that we don't take each other's property, it falls in line with the same ideas, right? Whereas it can promote economic growth and development for not only the nation, but for the world. And we see that because in our Constitution of the United States, Article 1, Section 8, Clause 8, it's the first time that any peoples have empowered an individual to have exclusive rights to what they create and what they envision and what they bring into practice for their intellectual property. And this is important because the governments can't take this, organizations can't just take it from you. And for the first time, it allows an individual to say that this is mine and I get to protect it. It is a quid pro quo, and we'll get into that in a little bit when Salu takes over. But it's interesting to think about it from a historical context because prior to the Constitution, we don't have this protections that spur innovation as quickly and as rapidly as what we've seen since the onset of the Constitution and the Patent Act. So we are the United States Patent and Trademark Office, a federal agency under the Department of Congress, which is part of the executive office. We have about 16,000 employees, and we maintain patents and trademark protections for the nation. We'll get into later today that when you're filing for a patent, you have to protect inside of the United States. And that's the most important aspect of it. That's what a patent grants you. That's what trademarks grant you, is protection inside of the United States, and why that's really important. So stay tuned for when Salu starts talking. One of the things that we like to highlight is that anybody can be an inventor. You can be an inventor. Your children can be inventors. Your grandparents can be inventors. Anybody can invent. And here's just wonderful examples of inventors that have come before you. People work as individuals. They work as teams. They see what problems are within their community, and they find real solutions. Oftentimes you can see what's going on not only in your community, but maybe in the world, or things that you've experienced. And then through the opportunities that are presented to you, you can develop new solutions and new ideas to improve the quality of life, to improve safety, to improve just the existence of what it is to be here in this world and in this time. And so we also have really just amazing rock star youths and adults and alike that are inventing. And so it takes seeing an opportunity and creating something new. Gitanjali Rao is a wonderful example of this. She was Time Kid Inventor of the Year, and she created a way to early detect lead contaminants in her local water. And this was important because this was something that plagued her region, and she wanted to make test kits that were readily available, inexpensive, and user-friendly. That was a big aspect of it as well. And so we celebrate these inventors and exemplify them, so that way you can see yourself as inventors and then go on and seek patent protections. And should you do that, please connect with our agency. We're here to help you. We're here to provide resources on your journey. Salu will shortly be talking about the 4 different types of intellectual property. I'm putting this on the screen right now as a little bit of a teaser for you, and he'll go into it in more detail. So really quickly, what I'm going to talk about is the Council for Inclusive Innovation. It's a mission that came to our agency, the United States Patent and Trademark Office, as a way in order to bring more individuals to the intellectual property protections ecosystem. Because we realize that if only certain populations and peoples are inventing and feel that they're invited to share their ideas and engage in this innovation ecosystem, then we're losing out on really great minds. And so we hope that you feel heard and seen, and that your ideas can change your life, the lives of your neighbors and people across the world through the inventions and the things that you think about and the solutions that you can discover. Within this Council for Inclusive Innovation, one actionable item that they did was to stand up the IP champions, this council for this community outreach campaign. So that's the program, Community Outreach Campaign. And what we do is we empower our USPTO employees as grassroots local educators. And we refer to them as our IP champions, going out into the community, connecting with individuals such as yourselves, the community amplifiers such as YEP. And we're trying to share not only this widespread knowledge that we have of intellectual property protections, but awareness and the amplifications of the protections and the entrepreneurship ventures that you and your peers embark on. And should your journey, of course, go down this road where you seek intellectual property protections, connect with us. We want to be a part of that journey with you and make sure that you feel comfortable and understand what it is that is the next best step for you in your journey. And so Salu, who I'm about to introduce to you, is an IP champion. And what he does is he directly educates your community. He discovers and amplifies IP narratives that exist within your community, and he supports the agency. So should you have other opportunities such as summer camps or STEM fairs and those types of opportunities, please connect with myself, with Salou, and let us know about how we can come into your community and better engage through intellectual property protection narratives and activities. We have a wide range of offerings, not just what Salou is about to share, but more hands-on activities for in-person, especially with youth. So far in the first 120 days, our 15 IP champions have had over 35 engagements. We've connected with over 980 students aged kindergarten through 12th grade. And we have, I think right now, as of today, we have 18 engagements planned throughout the summer. And so we want to make what you're interested in part of our schedule as well. And so with that, I'm going to introduce your IP champion, Salou. So Salou, welcome to the virtual stage, and take it away.
All right, can you hear me?
Yes, we can.
All right, thank you, Stephen, for a great introduction. By the way, Stephen is the architect of this IP Champion program. I can't thank you enough for coming today taking from your busy schedule. I know you're flying tomorrow, but so thank you for coming and join us.
I wouldn't miss it.
Yeah, thank you. I really appreciate it. Stephen talked more about what our office do. Let me give a background why we chose, especially me, I choose to communicate with YEP. So one of the greatest asset for patent office is a diversity. Diversity is a great asset in the U.S. Patent Office. So the reason I'm saying is there are two ways I communicate with YEP. The first one was USPTO has plenty of affinity groups. And one of the affinity groups is Society of Ethiopian American Engineering Scientists, which is part of the United States Patent Affinity Group. During that time, we connect with YEP to do IP symposium before. So that was the first time we connect with YEP. Now the office has different platform, which is a patent expert like me to send out to our community and to spread the word about intellectual property. So that's why we're here. I know YEP a collection of students and professionals. So who the best fit for this program other than YEP? So having said that, let me go to the slide. Let me talk about first. Let's talk about patent. Could you go to Reddit to? So go down. Steve already mentioned all of those. Go back. Yeah. So here there are one slide up. One slide up. Up. Yes. So now we are talking about four types of intellectual property. The first one is the patent. The second one is trademark. The third one is copyright. The fourth one is trade secret. So patent is a new idea, a new problem-solving method, and the trademark is the origin of the product. The copyright is the creative work of the producers or the writers. The trade secret, all companies have trade secrets, so they protect it by confining in a certain place for a certain period of time. So those are the four fundamental IP intellectual property. Let's go to the next slide. Okay. now let's talk about patent. So there are three types of patent. One, utility. The other one is design. The third one is plant. And utility patent, there are four categories. The first one is process. The second one is machine. The third one is article of manufacturing. The fourth one is composition of matters. So process by itself, it's just applying for process means. So if I want to, I don't know if you can see it. If I want to produce this, I just claim that how I can make this, the process. Okay, finding a material in a certain way, shaping it and mixing it in a certain thing and produce this. However, this process, somebody can come with different process to patent exactly this. So it won't last long, the process patent, because in this different way of the end product, it doesn't matter. So when it comes to machine is a tool to create something. That's another one. The article of manufacturing is like table, tire, and the phones in your pockets, all those called article of manufacture. So if anybody comes with those kind of invention, they can get a patent. So composition of matters is so one or more than two items combining and to create something. That's the fourth one. So design patent is all about the shape, what kind of ornament that person can do. So the utility patent can be held until for 20 years. The person who invented has exclusive right to have. So design design is for 15 years, and plant is actually by asexually reproducing plants, fruits, etc. So those patents can stay for 20 years. Let's go to the next one. Now, so patent is a new idea. So go to the next one, please. Yeah. Okay. So this is so once the patent or the idea formed in the mind, then it has to come in order to be applied to patent office. It has to be it has to have a drawing. It has to have described. It has to describe how it functions, and it has to have a claim. So the first time applicant come up with that forming a mind creation, then they can put it on paper. It has to tell the public how it works and what kind of invention they want to claim. What is the drawing? So after that, they have a year to do provisionally to apply for it, to have a placeholder, means to have effective filing date. So after that, they can formally apply for patent. Then it's gonna come to a docket like the examiner like me. So it landed in my docket. I can pick up that. So basically, the patent examiners, most of them are engineers. It can be mechanical, electrical, chemical, all kinds of engineers. So based on that, by trade, I'm electrical engineer. So anything related to that area, specifically, I am handling how image created, how input-output works, like touchpad, iPad, how head mounting device connected to other devices to create input-output. I am in that area. So if some patent comes to my docket, so I can see, first I have to examine what's the invention all about. I have to read the spec. I have to look at the drawing, and I have to see the claim. After that, then I do, the patent office has a gigantic database. So I do a search if somebody before this person invents such kind of invention. So if I find something similar, then I'm going to send it back to the applicant. John Doe has the same similar invention before you, so we're sorry, we can't give you the patent. Then the next one is the applicant can see my response, and no, this, either they can argue back or they can amend. So eventually, either the patent will abandon or will get a patent. Next. Okay, so the next one is a trademark. The trademark is any word, slogan, symbol, design, or combination of those that. So that it basically it tells the origin of the product. Let's go to the next one. So if you look at it, this one, so the trademark, it can be words, it can be sentence, it can be either just a symbol. So if you want to have either word, the word by itself, you have to apply for it. I believe it's $225 for application. And if you want to have logo at the same time, you have to pay another $225 for the logo. And so this trademark will be examined by trademark attorneys. It's not by engineers. It's an attorney. You have to be you have to have a law degree in order to examine as a trademark examiner. As you see, there are words, Starbucks, Nike, Target. That is logo, Starbucks, Nike, Target also. So that's the next one. So there are 4 types. You can apply in 4 ways. One, it can be color. The other one is it can be word. The other one is it can be even smell or sound. So you can have a different way to apply for a trademark. Next. Okay, for this one, for example, it's definitely a scent. So when you open it, each of them have different distinct scents. So that sense, it can be, nobody can regenerate it because somebody's trademark on it. Next. So this one is based on a sound. You know, if you that one is you guys too young to know that the guy on the left. So the whole idea is it's you can create something. You know, when you touch them, it can be sound. You know, in one way. So that musical sound actually it can be trademarked. And for example, during the news time, and it has to be a certain melody or taps to that sound also can be trademarked. So next. So I'm gonna do just a high level of it. I don't want to bore you with the detailed thing. That's why I'm running in a quick manner. Okay, so the copyright is a copyright. So it's protected by Library of Congress. I mean, it's stored in Library of Congress, and the term has, so anybody who write a book, for example, so that book has to be it has to have a copyright. Otherwise, somebody can reprint it and sell it for the hard work they have done. for a long time. Next. Next. So there are it can be stored in the copyright. It can be songs, it can be movies, it can be books, it can be sculptures. So any shape or form that one is, so nobody can generate it unless it got a permission from the copyright owner. All right, trade secret. So trade secret, actually, most of company have a trade secret. It can be a recipe for food, or it can be the way one company run business. So most big company, they have a trade secret. So they keep it in a very hidden area, or if it is software, it has to be encrypted. So nobody without the owner of that trade secret can't be use it. So the owner has a responsible also to keep it in a certain way, in a secure manner. Let's go next. All right. So this one is actually, I like this slide, because when you look at it, it tells you so many things. Actually, if anybody can say what can be patented by seeing this one, this picture, what can be patented?
So I'll take a guess and say the shape of it, or how it's kind of formed.
Great. Yeah, one is shape. Okay. What else?
The specific recipe, perhaps, to make it gluten-free.
Exactly. Yeah, that's it can be what? It can be a trade secret, right?
Yes.
That's secret sauce. All right. What else?
Maybe the name. I'm not sure of what this specific pasta is called, but I'm sure it has a very unique name. Maybe that's also.
That's also exact. Good job. We should hire you. What else?
I think I'm all out of ideas. Feel free to.
Only one left. Okay. You mentioned. So you can guess. You can guess.
I think taste goes hand in hand with the recipe. So texture. I see a comment.
Two. So one, it can be, they can write a recipe book, right?
Mm-hmm.
Yeah.
Okay. And that would be considered copyright.
Yeah, another the copyright part. So they can write a recipe book, and that can be part of the copyright. One more thing.
We do have a comment around the texture of it.
The texture, it can be, yes.
Okay. So we addressed the taste.
So how that pasta can it? Some tool be used to cut.
I see.
Yeah? So that's another. So go to the next one. So all the answers are.
I see. Okay.
So basically, this one by itself, it defines all the intellectual property process. All right, I will not bore you with the detail. So let's go to Q&A. I know you guys have so many questions, and let's get on.
Awesome. Thank you so much, Salu. I know I learned a lot, and although this was high level, I appreciate you covering the broad spectrum of different areas. And I know you've posted your information here, or the council's information here for people to reach out to. So folks, if you have questions, please feel free to drop them in the chat, and we'll go ahead and make sure that they're addressed. I know I have a couple of questions. So in terms of businesses that provide services, right? I know this is something that is becoming quite a big area within our community. Entrepreneurs, starting service-based businesses. What areas would we need to consider? And I'm asking selfishly as well. I can think right off the top of my head, perhaps the logo, right, for the business. But what are the different areas we should consider? And I'll bring Steve back on stage too, so he can give us perspective.
Sure.
All right, go ahead, Steve.
So yeah, so as you're starting your company, right, what is the most important aspect, right? When you were thinking about trademarks and our name and our logo, right, there's certain checks, whether or not it's like specific to you. It identifies to your customer the source of the goods of service, where they're coming from. And we want to protect that, because as you build that reputation with your clients, you don't want somebody to take that name from you or to misuse it. And so one of the best ways to do that is to get a trademark. So you would do a trademark search, which we have classes and boot camps on how you can do your own search, and then you file with the agency. The moment that you file with the agency, you get protection across the United States. As soon as you start doing business in your local region, you do have trademark rights, but they're specific to where you're selling your product. But once you put it into the database and you get that trademark, it's across the United States. You get protections, and then also it gets registered with import-export, so with our border patrols. So that way, if somebody's trying to bring in a counterfeit product and it goes against your trademark, then it gets seized at the ports. So it's really a lot of protections for not a lot of expense, and it can really help out in the long run, if you will. So there's a lot of people who say trademark protections is one of the most important things early on. I think if you're interested in finding a fun story, Burger King has a pretty interesting one where there was a small, burger shop that was called the Burger King, and they were very localized. And it's my recollection of what's currently going down is that Burger King exists within the county that they have their shop, and then every other Burger King in the United States is the one that we know as Burger King. But because the small shop predated the larger licensed Burger King that we all know, anyways, if you're interested, you can go check it out. And so I think that highlights the importance of federally registering the trademark early. Yeah, does that help?
Yeah, absolutely. That's definitely helpful. I'm thinking from the context of, we may have certain unique processes, right, that go into how we develop our solutions and implement services. So something like that would be patent, correct, as opposed to any of the other three options.
Yeah, and again, when you develop an idea, going forth and doing a patent search, and just because what you're thinking, if it has already been invented, does not mean that you might as well just fold up shop and walk away. One, patents have a limited lifespan. So if the technology that you come across was 20 years or more, then likely the patent has been invalidated, just because, not invalidated, but it is expired. Sorry, not invalidated. It is expired after 20 years. And so you can freely use that for whatever venture you're looking for. Otherwise, there's licensing agreements that you can get into. But one fun thing is that if you do come across a process and it is patented and it does exist, we can think of the whole patent system as the largest repository of how-tos. You can do a patent search to modern day time and figure out what problems people have encountered and what solutions they put forth through inventions. And then that's kind of the point of the system, because if you know what the cutting edge of technology is for the thing that you're interested and passionate about, now you're at the front end, right? Whatever you think of next may not have come before you, because you are smarter than everybody else. You've learned from everybody else that's come before you. So
yeah,
in a way,
that's great perspective, like a Google for, searches, what's already been done and improvements that have already been made. Awesome. We do have a question from the audience.
Just to add on that,
Sure.
it's not just patenting. I mean, you can invent something, but if somebody see, we give patent, not the new not only the new invention, for improvement also. If you see something, if you know how to improve it, you can get a patent. even in the process, like if you do a different method of, additional method of to improve the previous patent, you can get another one. Yeah.
Interesting. Does that incremental improvement have to be, what's sort of that threshold, right? You may have A, B, and I just come along and add C, so it's very minor in the grand scheme of things. But what's sort of the threshold for that improvement increment?
Yeah, so I'll take that. That's why we have patent examiners such as Salu and myself. It has to be novel and non-obvious, and so it's a gauge on what is the skill of one of ordinary skill in the art. And so we say that pretty casually around the United States Patent and Trademark Office, but it is different for different fields, right? So if you're inventing a brand new gym bag, one of ordinary skill in the art may be considered to be different than somebody who, for instance, is thinking of a brand new organic light emitting diode that's going to exist inside of your iPhones and your Apple Watches and such, right? Because it has higher illuminations and higher cyclability and such like that. So we have specialized examiners for different fields in order to be able to assess what that one of ordinary skill in the art is. But really, it's showing that there's a use, there's an improvement, right? So we can quantify and qualify improvement, whether it's comfort or longevity of a device, right? These types of things that we can support that our invention is meaningful and a meaningful advancement over what's previously been done in the field of endeavor that we're inventing in, is how you can better position yourself to secure a patent.
And to add just one more thing. So for example, you have a phone, you have a keypad, right? So the keypad is very tiny, small one. So if you have a fat finger, you can hit actually 2 keys at one point, right? So one person come in, okay, instead of to show them, based on the sensitivity of the key, I can press, when I press it, there is a bubble coming out the letter. Like if I press, like you might see that, it is pretty all over. Then that improvement by itself, you press it, when you press it, the bubble is coming out, you hit the right key. So that's another improvement for the keypad from input-output side.
Great. Yeah, that's a great example to help us sort of understand. I encourage everyone that's tuning in, please drop your questions. I do have the one audience question I want to bring up regarding the drawing and form of function. How detailed is a successful patent application?
So with this, we always say this is not legal advice. We can give our 2 cents as patent examiners, being employed at the agency. But of course, we like to think that the patent application is your communication to the world, and that may differ than how somebody else in the legal field may want you to represent what your inventive concept is. But anecdotally speaking, what we see is that a patent application is your contract that you want to have with the United States government saying, here's how you invent this new concept, right? Here's how you create this new concept based off of what I invented in my mind and then brought into practice. And you get the quid pro quo is that you get the monopoly on that invention for a limited amount of time. So you have to reveal with such specificity, again, one of ordinary skill in the art would be able to read your description and then build it, right? And so that's kind of that's an enabling description. And so you want to make sure that whatever makes your invention special, those aha moments, right? The things that differentiate it from other patents that have come before it, that is in your patent application. If you've never, I assume most people have never written a patent application, but it's actually pretty interesting because if you go through it as like even just an intellectual pursuit, just trying to write down how you would solve a problem with a brand new invention. And oftentimes you may find that just by writing it down, that is part of the inventive process. You get better and your brain opens up and you start thinking of new ways, new additions that you could add to your invention to make it better for your specific niche market that you're trying to create a product for. And so, give it a shot. Give it if you have an idea, try to draft a patent application. And one of the best ways to do it is to search the patent database to see what's already existing, and then try to mirror the language and the syntax and how they present the information. And as long as you can do that, I think it's at least a fun intellectual pursuit, but then also you can start to see how your invention fits in this system. But again, not legal advice. That's why I kind of framed it the way that I did. So hope that's helpful.
Yeah, I think to add to it, so usually like there are specifications, you can invent any superb invention, but what you get a patent for is for how you claim it. So writing the claim is very, very important. So as an examiner, we see when we read your claim, we brought it with reasonable interpretation. We do broadly interpret it. So with broadly interpreted, the way you write it, you can be your invention is this one, but I can reject you with a table because of the way you write a claim. So crafting the claim is the most important part. And if you search your invention, try to search based on your crafted claim.
Are there any resources that you could think of off the top of your head that could help someone? Stephen, like you said, I have never even looked at a patent application, let alone put one together. So thinking about are there free resources out there that could help us in crafting such information?
Sure. Great question. Wonderful question. And we're always trying to develop new tools to help, especially under the Council for Inclusive Innovation. The more we can reduce the barriers to getting your ideas out there or seeing if your ideas are out there, the better our whole system works. Right? And I fundamentally believe that to be true. And so we're always trying to push the envelope and make these resources more available. And so if you type into an internet search browser, it's United States Patent and Trademark Office or USPTO and the word search. We have a public search tool. And you can play around with that. You can just see what you can find. We have search classes through, we can help connect your organization with a PTRC library. We also have events that are ongoing that help you get better at doing a basic search. Again, so that way you can discover what inventions exist in the field that you're interested in. And then you can go from there, because searching, I think, is one of the first steps, knowing what's out there, what's come before you. And so that's really great insight that you're asking that question about, like those specific resources. I think there's also teams that are developing how can we help people draft patent applications and go a more pro se route. We also want to highlight that there's opportunities at the United States Patent and Trademark Office called the Pro Bono Office, where lawyers volunteer their legal time in order to help people draft and get their patents examined at the United States Patent and Trademark Office. And that's based on, it's an income-based process. So it's if you're in need, then they can potentially provide assistance. And so if there's those specific questions, if you're at that stage where you have an invention, you want to bring it to the practice, and you have a roadblock such as finances or just not knowing what the next step is, and this has encouraged you to take that next step, reach out to us, because we're here to listen to you specifically and to provide that next step. And from the people that we've worked with, we can't capture all of the metrics, because sometimes metrics of converting your ideas into a patent or into a trademark, sure, we might be able to track that success story, but it's also a success story if you have this idea and then you realize that it's already been invented, it already exists, and then you move forward with it, right? Because an idea in your mind can act like a roadblock if you don't do anything with it. You may think it's the greatest idea, and it might be, and it might have been, but it might have already come before. And so we need to take that idea and find out its viability. Can it be patented? has it been patented? What's at the end of that road? What's at the end of the journey? And so by taking these next couple of steps, it releases you and that thought, and then you can move past it and you can move on and you can innovate and invent the next best thing.
That is extremely helpful to hear. And I'll go ahead and pull up again. This is the contact information for the Council of Inclusive Innovation Community Outreach Campaign. And it seems like the uspto.gov website is really the first place to go to either look up existing patents or to get ideas around potential resources. So I did go ahead and drop that in the chat for everyone. Please use that as your first resource to do your research. If you have questions, reach out to the office with this information listed here. And I encourage you, we do have a couple more minutes left. So if you have any questions, let us know, drop them in the chat. While the audience is posting any last minute questions, I do have one more. And that is related to the process. So in the slide that we looked at earlier, there could be about a year between your first submission and then throughout the whole process. Are you technically covered under like an interim, or temporary coverage? Because I think about, I might have the next best idea and I'm still going through the process and someone else might also have it and kind of beat me to it. So what are the protections that are put in place for someone that's already in the process?
Mm-hmm. Let me take first, then you can go ahead. So the first one, so the patent process. So the first one is, so there is, as I said, a placeholder, which is provisional application, and that one you don't have to be a formal. So you don't have to write a claim.
Okay.
That the main part is claim, right? An invention. So you don't have to write the claim, but you can do specification and the drawing and submit the application. So you can have that effective filing date from that filing date. So then after 1 year, you have to formally file the patent, including the claim. So you can use a placeholder for that. And the other changes, before it used to be first to invent, now it's first to file. So that to first to invent, you can start probably 5 years ago, and if you have evidence exchanging with your colleague or something, you can present that evidence, and even down the road, so you can get that effective filing date from that. Now that's changed. So unless you file it, it doesn't matter when you start the invention. So it has to be first to file. Go ahead, Steve, if you have any.
Yeah, and just to echo that, first to file is where we currently are. It's basically calling dibs, and so you can do that with the provisional, the non-provisional, as Salu said. I think one of the things to also highlight is that you don't actually need to produce the product, right? So if you believe that you have the next best gym bag and it includes straps, zippers in a specific location, you don't actually have to create the physical invention because it's in your mind, right? And you know that it works and it doesn't break the laws of physics, right? And you can file an invention, an invention disclosure through a patent with the agency in order to secure that. And so I think that's kind of one of the myths, is that you have to bring it to practice, and you don't necessarily have to anymore. At the very beginning, you had to create a patent model. So it was actually a miniature version that a patent examiner would take and use and then be like, yeah, sure, you get a patent for it. But yeah, no, now it's just all paper and it's electronically filed, and then we look at it against the prior art. So yeah.
Great. That is helpful to know. Awesome. It looks like we do not have any additional questions from the audience. I did want to ask one more from my curiosity. Once the trademark period of 20 years is up, are you allowed to reapply, or at that point it's someone else has to then ultimately apply and hold a trademark?
The one I know, so you get a trademark. For example, let's assume you get a trademark, right? So once you get a trademark, you have 6 years. So usually, like when the end of the 5 years, the applicant, if still own that, so it's completely different with the patent. If it still hold that belonging that the trademark, then you have to reapply again. So it will give you another 6 months. 6 years. So,
Okay.
so that's what I know. I don't know if you.
Yeah, just to clarify, yeah. So a patent utility, that's the thing that we hear about on Shark Tank. Do you have a patent for this device? They're talking about a utility patent. That is 20 years.
Okay.
The other flavor is a design patent, which is increasing in popularity, and that's an ornamentation design on a device. And so it doesn't have new function and utility. It's just the way it looks. That's 15 years. But as Salu's saying, like with trademarks, you can keep you can keep extending your trademark. I mean, Coca-Cola has a trademark because they keep extending it. Pepsi, Delta Airlines, right? They don't have to go through a complex system in order to do that. They just keep, extending their trademark. But the big difference is that utility patents and design patents and plant patents have a limited time, that although within that time window you do have to pay to maintain your patent rights to it, there is a cap, there's a limit on it. And the whole purpose of that is so that way you have that limited period of time, so that way you can create your company, get off the ground, you are the front runner in this technology, but that way you keep improving and you keep bettering your own product, because after 20 years, competition can come back in. And so we start to see that it's a benefit to society and the innovation ecosystem, because those that are most in the know about their technology are still improving. So that way, when that time expires, they still have protections for their next product and the product after that in the next iterations. So, yeah.
Yeah, so it's important to know some of these are not necessarily one and done. It's something that you have to continually think about the renewal process. Okay.
One more things to add. So yeah, the trademark part. So once if I don't claim in that 6 years period, somebody can take over exactly the same thing and they can apply. So that's a difference between patent and in patent. Actually, after that the year end, it's gonna be a public. It's owned by the public, so nobody can claim again that invention and I'm gonna do this way, because that's where we're there. So we can find from the database it has been patented before. So this is the public, owned by the public. So that's that.
One thing to talk about with trademarks, as we're having this kind of we're digging a little bit deeper into the what a trademark means, is that you can't just file a trademark and say, you have to pay me $1 every single time you say my company name, or I bar people from it. Like, because the essence of a trademark is that it's the identifier of the goods of the source of the product, right? So if you were to walk into a McDonald's and they were selling electronic goods, you'd be like, what's going on? As a consumer, you don't understand what's going on, right? So that would be weird, right? So even if you were an electronics store, but you said McDonald's, right? Like, you wouldn't be in compliance with the essence of what a trademark is. And so in that same vein, if you don't actually have a company that you are producing a product or a service, then you might run into issues if somebody were to litigate against you and say you don't actually have a company because you don't have goods or services that anybody would recognize. So you have to you have to build that brand recognition and then protect the brand recognition. So it's just something to think about in terms of, like, the USPTO is not asleep at the wheel. There's an underlying purpose for the trademark system as well as the patent system, and people operate in good faith in it. And also, like, trademarks themselves are dependent to the field of endeavor. So when we see Delta, we know of Delta Airlines, but there's also a faucet company, Delta. And so they're not in conflict with each other, because if you're at Home Depot and you see Delta Faucet, you don't necessarily think that you're getting a free trip on an airplane with it, right? So you can still have these situations that arise where people are using the similar names or the same name, but they do try to. That's a whole other conversation outside the scope of what we're talking about today, but just planting little seeds.
Yeah, I appreciate you diving a little bit deeper into that.
Cool.
I think one thing to add, not this one's completely different topic. So we know that YEP is comprising with the students and professionals, and patent office has actually a career opportunity if you're looking for one. So that's a very decent paying job, I think, and yeah, you feel free to apply at usjob.gov and see what patent examiners do.
Yep. You do have to be a U.S. citizen, so that is important to highlight. But if you would like to have us come back, we do a discussion about what it means to be a United States Patent and Trademark Office patent examiner or to work with us, so that if that's something of interest to you and your organization. I also do want to throw one last plug in that if you know of summer camps, reach out to Salu through that email and let us know how we can better engage your communities through IP narratives and storytelling.
Wonderful. Yeah, I sincerely appreciate your time and you sharing your expertise with us. I think definitely career opportunities, that's our backbone here at YEP, right? Career development. So we'll definitely either connect around sharing items on our Career Elevate newsletter or any other resources that we're able to provide. And then, of course, just continue to have these kinds of webinars and discussions. So I sincerely appreciate both of your time. For everyone that joined in, dropped questions, and interacted with us, thank you so much. I do want to give a plug for YEP. Please make sure that you're following us on all social media networks. We do have an event coming up on Thursday, June 6th. This will be Founders Hour, where we're going to have a panel of entrepreneurs. So kind of similar to the discussion we've had today of folks, innovating and creating products and services. So we'll have that panel discussion and more information will be shared on our social. So please do follow us. With that said, again, thank you both so much for your time, and thank you to all our audiences, and have a great rest of your night.
Thank you very much.
Bye-bye.
Bye.